Hello, and welcome back to Class 2 of Intellectual Property. Today we're going to be talking about the tort of misappropriation of information, which is often better known as the hot news doctrine. And you'll see the tort of misappropriation listed in the forms of intellectual property that I briefly laid out for you in our last class. And specifically, the tort of misappropriation goes to the misappropriation or use of valuable information generated by one party, by another party, typically by a competitor. And we'll talk about why that by a competitor element is so critical to the tort of misappropriation as we discuss how it plays out, or rather how it was created and how it plays out in practice. And we can also reflect on the extent to which the role of the competitive relationship plays an important function in determining whether and when intellectual property rights of various kinds attach in various circumstances. Right? So some kinds of intellectual property rights apply against the world as a whole. So for example, patents and copyrights, at least in theory, apply against the world as a whole, although typically infringement by competitors is the most frequently objected to form of infringement by patent and copyright owners. Other kinds of intellectual property rights, particularly trademark, are really about competition per se, and therefore are about the relationship between competitors in a market. So the unfair competition element is really critical to thinking about when those intellectual property rights can be asserted in the first place and what they're intended to accomplish. And the tort of misappropriation, as well as the related concept or tort of the misappropriation of trade secrets are really great examples of that. So we'll be talking about those in this first segment of the class over the course of the next several sessions. Okay. Well, the tort of misappropriation, or as it's been come to be known, the hot news doctrine, kind of found its first and most kind of canonical articulation in the 1918 Supreme Court case, INS, or International News Service v. Associated Press, in which a split court kind of opined on when news aggregation organizations or press organizations could claim exclusive rights over the news that they generated and disseminated. So a little bit of historical background, just to kind of explain what was happening in this case and why it was so contentious. So as you may well be aware, in 1918, the United States had recently become embroiled in what now became known as the First World War, which at the time was known as the Great War. Of course, nobody knew there was going to be a second one yet, and so they just referred to it as the Great War at the time. And the news business was changing. Right. Among other things, the news business was changing as a result of the introduction of the telegraph, which enabled the dissemination or transmission of news information over very, very long distances very quickly. Right. Previously, news had traveled at the speed at which information could be sent via mail and so on. The telegraph enabled news to be sent, at the speed almost of modern communication, certainly much faster than any kind of news could have been disseminated previously. And as a consequence, we also saw a dramatic consolidation of news gathering enterprises and the rise of these news gathering organizations. The Associated Press, of course, which is still around and is probably the best known of these news aggregating organizations. But the INS was a competing news service. And essentially what happened was that the Associated Press decided on particular newspapers in particular geographic areas that were going to be its clients, and it would provide the news it gathered only to those clients. And newspapers that weren't members of the Associated Press needed somewhere else to go to get news as well. And so competing news organizations were created and developed in order to service the competitors to the Associated Press clients. Now, in the moment, right, the kind of baron of the newspaper industry in the United States was William Randolph Hearst, pictured here on the slide. And Interestingly, Randolph Hearst was both the primary, or the kind of plurality member, as it were, of the Associated Press, because he owned more AP newspapers than anyone else. But he was also the founder and owner of the INS, right? So he was kind of on both sides of this particular case. And that's particularly important and interesting because Hearst at the time was seen as being excessively pro-German and anti-English in terms of the sentiments that he sort of pushed in his papers. And as a consequence, the British government refused to allow INS reporters access to news gathering and reporting in the theater, the theater of war, to the same degree that the Associated Press was able to have access to collect and disseminate news. So as a consequence, INS was at a great competitive disadvantage to the Associated Press in reporting on what was the sort of major news event of the day, namely what was happening in the war overseas, right? So the Associated Press was able to gather extensive news, wire it back to the United States, and report on what was taking place. The INS was really hamstrung, right? Because its reporters couldn't get the same access, and therefore was a huge competitive disadvantage for them in terms of reporting on the news in the United States, because they just couldn't gather as much of it, right? But they found a workaround, right? So what happened was the Associated Press would report news back to New York, over the course of the night, and put together the newspaper, and the newspaper would hit the newsstands, the crack of dawn, early in the morning in New York City, and the news would be available to everyone who wanted to read it. But because of the time difference between the East Coast and the West Coast, right, the Associated Press wanted to delay the release of its West Coast papers until it was the morning there. Right? There's no point in releasing papers in the middle of the night on the West Coast. And, they needed time to develop and print them and so on and so forth. So if the news was released at 5 o'clock in New York City, right, they would wait until it was 5 o'clock on the West Coast to release the same news there. Well, INS saw this as an opportunity, right? What they were able to do was go around to the various newsstands and various places where news was being disseminated, collect the news themselves, right? And then wire the news stories to the West Coast to the point where they could either catch up with, or in some cases even beat, the Associated Press to bringing that same news story to consumers on the West Coast. In other words, they couldn't compete on the East Coast because the Associated Press had the news first and was able to get the news out first, but they could collect the news from the Associated Press and provide their own version of the reporting on that news on the West Coast. Now, understandably, the Associated Press was not thrilled about this, right? They invested all these resources into collecting the news and putting the stories together. And they didn't love the idea of their primary competitor essentially free riding, as it's put, on their effort to achieve the same goal without having to invest any of the same resources in collecting the news in the first place. Now, of course, that objection is tempered somewhat by the fact that they did have the first mover advantage. They were able to publish the news first on the East Coast, and so they had a huge jump in the biggest market in the United States. And at least in theory, they could have released the news earlier on the West Coast as well. It just wasn't really as much in their business interest to do so, and there were reasons why it was more convenient for them to delay, and they didn't like their competitor horning in on their labor. And so they brought this action under federal common law at the time against the INS, arguing that the INS had engaged in misappropriation and that its improper behavior entitled the Associated Press to get an injunction against the INS engaging in this kind of activity. Now, notably, right, the Associated Press did not bring a copyright infringement against INS. It only brought this misappropriation action. Why was that? Facts are complicated, but broadly speaking, sort of the rationale apparently was that INS wasn't copying the stories literally. In other words, INS wasn't taking the news stories and literally copying them word for word. What it was doing was taking the facts and information and ideas in those news stories and paraphrasing them in its own stories. Now, copyright as we'll learn later in the class, only protects particular expressions of ideas. It doesn't and can't protect facts and ideas, right? So at least in theory, the reason that the AP was not bringing this as a copyright infringement action, but only bringing it as a misappropriation action, was because the INS wasn't actually copying the stories. It was just copying the content of those stories, and that can't be copyright infringement. It doesn't mean the AP objected any less. It just means that the kind of objection that they made was a unique kind of competition-based, unfair competition-based objection, not a copyright objection. Okay, well, a majority of the court, in an opinion from Justice Pitney, found in favor of the Associated Press and said, look, INS has improperly misappropriated information gathered by the Associated Press, right? The Associated Press invested a huge amount of resources and time and energy into gathering and collecting this news and fashioning it into news stories, right? The INS hasn't invested that same kind of time, energy, and resources, and it's unfair and improper for them to take advantage of the Associated Press's labor without having done the labor on their own. Essentially, right, the majority of the Supreme Court says, look, news is valuable only when it's fresh. The reason the INS is taking this news that the AP is reporting on is because it's fresh news, and they want it while it's still valuable. And so their act of appropriating that information from the AP becomes misappropriation to the extent that they're trying to grab some of the profits that rightfully belong to the Associated Press as a function of its investment of resources into the generation of that news in the first place, right? Nothing's less valuable than yesterday's newspaper, right? INS wants to get in on the action while it's still valuable rather than letting the Associated Press grab the entire banana, right? And as a consequence, the majority of the court says that under those circumstances, that's unfair competition. It's not fair for the INS to be taking advantage of the Associated Press's labor. Now, of course, the majority says, look, if INS wanted to send its own reporters to the theater of war and report on events itself, that would be totally fine. The Associated Press can't own the facts about what happened, right? But it's still improper for the INS to free ride on the Associated Press's labor. And interestingly, the majority made an additional distinction, right? They said, look, individual consumers who buy the newspapers distributed by the Associated Press are perfectly entitled to further disseminate that information. But that's because they're not the competitors of the Associated Press, right? Essentially, the majority of the court said, look, the problem here is that INS and AP are competitors in the same market, and the INS is trying to improperly use the Associated Press's labor in order to unfairly compete with it, and that's the kind of thing that we can protect the AP against. It's the kind of thing we can prohibit the INS from doing, and essentially it says, look, there's a kind of quasi-property in this hot news that justifies giving the Associated Press a reasonable opportunity to derive the appropriate amount of value from the labor that it's engaged in, right? So we can see a lot of the themes that we talked about in our last class around theories of justification of intellectual property, right? Essentially, what the majority here is saying is, look, the Associated Press has sown its labor in the field of journalistic fact gathering, and it's entitled to reap the fruits of that labor. It's entitled to profit from the reward generated by the work that it's engaged in, and the INS is not permitted to improperly horn in on its ability to fully realize the value that it's generated. Now, of course, the court did kind of hedge a little bit on that front and say, well, it's not a ownership that lasts forever. It's not a form of quasi-property that exists in perpetuity. It exists only so long as the information remains fresh, right? So the AP does have a certain exclusive right under the majority opinion in the case to use and disseminate the news in question without its competitors being able to take advantage of it. But that exclusive right expires relatively quickly, right? It expires as soon as the news is no longer hot, so no longer brand new news, and it expires as soon as the news doesn't have value in the competitive market. Now, there's two really interesting and important dissents to this case. The first comes from Justice Holmes, who says, look, this is really a copyright case in disguise. And because copyright doesn't prohibit what the INS is doing, the common law can't do it either. There can't be a tort of misappropriation if there's no copyright protection in the first place. This is ridiculous, right? I mean, maybe we could create a new law that would prohibit this kind of behavior, but the law doesn't exist. It's up to the legislator to create it. The courts shouldn't be doing that. And really, the fundamental problem here is one of misrepresentation, right? The problem, according to Holmes, is not that the INS is unfairly competing with the Associated Press, but rather that it's not crediting the Associated Press as the source of that information. As a consequence, essentially Justice Holmes is saying, look, this is really a plagiarism case, right? This is a case about the INS using the labor of the Associated Press without properly crediting that labor. That's improper. But so long as INS credits the information to the source, there shouldn't be a problem at all, and no injunction should issue. The INS ought to be able to report on the facts about the world. After all, the INS doesn't own those facts, or the AP doesn't own those facts in the first place. There's nothing in the law prohibiting the INS from reporting on them. It just needs to be candid and honest about where it got those facts from. Right? So really, Holmes sees this as more of a plagiarism case. By contrast, Brandeis takes a similar but interestingly different position, seeing neither any basis in copyright law for finding a violation, nor any obligation to credit. Right? Essentially, what Brandeis says is, look, again, nothing stops the INS from reporting on this news. The legislature hasn't decided to create this kind of protection, and news isn't property in the first place. So passing off news, right, failing to attribute the news to the source from which it was derived is no kind of violation because it didn't belong to anyone in the first place. Right? According to Brandeis, AP has no business insisting that the INS attribute the news to itself because it doesn't have any meaningful or legitimate proprietary interest in the news in question. But Brandeis makes another really interesting observation, which is that according to Brandeis, this is really just a question of market management. Right? What we have now is a market which is kind of a free-for-all, and these companies generate and disseminate the information in whichever way they wish, but nothing says it has to be that way. Right? I mean, Brandeis was the sort of archetypal New Dealer, or kind of pre-New Dealer, I guess, archetypal legal realist, archetypal believer in the potential benefits of regulation. And Brandeis essentially says, look, if the government thinks that we need to have a more regulated market in news in order to increase efficiency, it could certainly create certain kinds of market obligations for people using news from one source to pay for it in various ways. But it needs to do that on a properly regulated and flat scale basis. In other words, if the government wants to say we're going to have a regulated market in news, then everyone needs to have equal access to that news, and the Associated Press can't use its special access and market power in a way that's itself anti-competitive, right? So one of the really interesting things about this case is the way in which we kind of can see either party to the case as arguably behaving improperly, depending on how you frame the relationship between the two and depending on how you frame the kind of the nature of the market in question. In other words, is it unfair competition for the INS to be like lifting news from the Associated Press without putting in the labor? I mean, is the INS engaging in unfair competition by way of free riding? Or is the AP engaging in unfair competition by virtue of being the largest competitor in the market and in effect sort of capitalizing on the fact that its competition can't generate the kinds of information that it would be necessary for them to compete on their own, right? So it's a really tough question about how we ought to think about the relationship between the parties and what we mean by unfair competition in the first place. And I think it's a nice opportunity to think about the theories of intellectual property that we talked about in our last class. In other words, if we were to characterize the way that the different justices are thinking about the nature of justification of intellectual property in this case, kind of how would we pin it down, right? To what extent are they thinking about this economically? And they use the term free riding a lot, right? Is what they're really saying here that, well, we need to give the Associated Press the right to exclusivity in order to provide sufficient incentive for the Associated Press to generate the news in the first place, and that if we don't give the Associated Press exclusivity, then maybe it will lack sufficient incentive and the public won't get as much news as it would otherwise get, and therefore the public would actually be harmed, right? In other words, are we talking about a consequentialist type argument about benefiting the public really less than benefiting the Associated Press? There's certainly elements of Pitney's opinion that seem to trend in that direction, as well as elements of the Holmes and Brandeis opinions as well. Or are we thinking about this in a more of a moral sense? I mean, some of that same kind of language is there as well. This idea of the generator of a work of authorship, the generator or the producer of information, having the right to benefit from the fruits of their labor, right? There's certainly a labor element going on in there as well. And the very idea of unfair competition kind of presupposes that fairness and perceptions of fairness are driving the outcome. And those are pretty morally laden ways of thinking about the way we go about engaging in regulation. In other words, should we be thinking about this, about fairness in relation between competing actors in the market and how we're going to allocate the benefits that are generated? Or should we be thinking about this ultimately in a policy sense about what's going to be beneficial to consumers? And how might looking at the problem in those two different ways cause us to think about it differently? Okay, well, let's move on to talk about the other case I asked you to read, a much more recent case, but wrestling with really similar problems. This is the Barclays Capital v. FlyOnTheWall.com case. And in a nutshell, really, what was happening here was that a group of investment banks over the period of, a very long period of time had engaged in the consistent practice of paying a large staff of analysts to gather a great deal of information about different companies that customers might potentially consider investing in, produce reports for their customers, wide range of different customers, sort of explaining the situation at these different companies and making recommendations about potential investment decisions in the companies in question. And essentially what those banks would do would be to generate the reports, send the reports to their customers, and then several hours after their customers receive the reports, then make those reports available to the general public. Well, as a consequence of that, to the extent the reports provided valuable information, and to the extent that the recommendations were valuable with respect to decision-making in the market, these banks' customers then had a jump on the rest of the market with respect to knowing what kinds of information the banks were providing, and in particular with respect to knowing what kinds of recommendations the banks were making about investment decisions. And of course, a lot of people who weren't the customers of these banks entitled to receive the reports in question were also interested in this information and wanted to get access to it. And so the Fly on the Wall, like other financial websites operating at the same time, was essentially an aggregator of this kind of information. What the website did was collect these reports and get them out to its consumers as quickly as it possibly could, right? Essentially, the idea was, look, the bank customers are getting this stuff in the middle of the night, really early in the morning, at a time when it's, valuable for them to have information that other market participants don't already have. We're in the business of trying to get you that information as quickly as possible as well. Now, some banks just went ahead and sent information directly to Fly on the Wall, presumably paid for it, or who knows exactly how that worked. But a lot of banks were trying to keep that information siloed, trying to prevent companies like Fly on the Wall from getting access to it. But insiders of the company, sometimes customers as well, would send that information on to Fly on the Wall anyway, and Fly on the Wall would report on it. Now, Fly on the Wall kind of was engaging in two different kinds of reporting. In part, it was reproducing the reports as a whole, but in part, it was also just reporting on the actual recommendations themselves. Right? So the banks, or rather a group of the banks, including prominently Barclays Capital, brought two different actions against the Fly on the Wall. One was a copyright infringement action for copying the entire reports, and that was successful. Right? There's no question about that. Look, the reports are protected by copyright. The barrier for copyright protection is low. The reports were being reproduced verbatim with no permission from the banks that produced them. That's a per se copyright violation. Very easy for the courts to resolve. The tougher question was the bank's hot news claim, right? So essentially what the bank said was, look, just like in INSVAP, right? We spent a bunch of time gathering, synthesizing, collecting, and producing this information and coming up with these recommendations, right? We invested energy in this, and it's news, right? We're reporting on things that are happening in the real world. That's news. We're entitled to a certain degree of exclusivity in exactly the same way that the AP was, right? In other words, if we're generating the news, we're investing energy in producing the news. It's valuable news to the public. We're entitled to exclusivity, and the Fly on the Wall is infringing improperly, right? They're unfairly competing with us by distributing that news simply by virtue of getting a hold of it without doing the labor themselves. Could they report on all this stuff themselves? Of course they could, no problem, right? Anyone can report on anything they want to. The point from the bank's perspective is they can't misappropriate our labor in generating and synthesizing this information. They have to do it themselves, right? Well, did the court ultimately find that convincing, right? The lower court said, yeah, that sounds right. This is a hot news claim. Barclays et al. Ought to be able to prevail. The Second Circuit reversed, however, right? And why is that? Well, it said on one level, and this is interesting, I think, and important to remember, right, that INSVAP was originally decided under general federal common law, right? So think back, right? Remember Erie Railroad v. Tompkins, right? INSVAP was decided before Erie, and so it was decided under a theory of federal common law tort of misappropriation. Of course, after Erie, there's no such thing as a general federal common law. So kind of Erie effectively overruled INSVAP sub rosa, but the court nonetheless recognized that, look, even though the federal common law version of this doesn't exist anymore, a state tort version of it, in theory, could still exist. Right? So states might have a tort of misappropriation, hot news doctrine, even though the federal version no longer exists. So then it had to look to New York law, where this all was taking place, and say to itself, well, look, under New York law, is this the kind of thing that could possibly constitute a hot news misappropriation? And importantly, to what extent would a state tort law of that kind be preempted by federal copyright law? Because there's a lot of overlap between the two, right? We're talking about misappropriation of facts and ideas, right? But that there's a lot of crossover with copyright. Copyright normally would say that kind of thing can't be protected in the first place. To what extent can state law say that kind of information can be protected from misappropriation? Well, in a sense, the court kind of punted in this one, because what it said was, look, it's true that the banks are collecting information and reporting information about what's happening with these various companies. And at least at one point or another in the history of the Fly on the Wall, they might very well have been infringing on that reporting, especially by copying entire reports and posting them to its website, which was copyright infringement anyway, mind you, right? But the court says, look, at this point in time, what the fly on the wall is actually doing is reporting on the bank's reporting, not simply reproducing the reporting itself. In other words, the kind of reporting that the fly on the wall is doing is actually reporting on the recommendations being provided by the banks, not simply reproducing the reporting itself. And reporting on the recommendations is itself reporting. In other words, when the banks produce these reports, those reports become news. Right? They're news themselves because they're news about the recommendations that the banks are making and the predictions that the banks are making about what's going to be happening at these companies and how to think about the investment opportunities at these companies. That in itself is news, especially because the fly on the wall is reporting on a lot of different banks, which presumably are coming to different conclusions and giving consumers sort of a basis for comparing the different kinds of information that's being provided. Moreover, the court says, look, the fly on the wall isn't really competing with the banks in the first place. In INSPAP, the two news aggregating companies were direct competitors. They were both producing information that would go out to different newspapers. Our wire services are competing with each other. By contrast, the fly on the wall is just producing the information qua information. They're in the business of selling information. That's not what the banks are doing. The banks are producing these reports in the hope that their customers will use the reports as the basis for doing business with the banks. In other words, from the bank's perspective, the reports are kind of a loss leader for trading. They're not something that the banks are providing for its own sake. Right? So in other words, what the fly on the wall is doing is not competing with the bank's business model, but rather providing information for consumers and for investment participants in thinking about what ideas or kind of what recommendations are floating around out there in the market. They aren't themselves establishing any of these trades. And in fact, the banks have no ability to force their consumers to do business with them as opposed to someone else, right? Whether the customers of the banks get the information directly from the banks or non-customers or customers get the information from a company like Fly on the Wall, whatever, they could always go to another bank broker to make these trades. And the brokerage business is really where the business model of the banks is. So among other things, the court says, look, to the extent that the hot news doctrine, the tort of misappropriation, is about unfair competition between market participants, they're not in the same market. So the tort just isn't appropriate under the circumstance. Okay, so for the purpose of our discussion, I'd like you to reflect on both these cases and think about whether or not you think the court in both cases got it right. In other words, is having a concept like the tort of misappropriation in the first place a good idea, right? Is it really unfair for businesses to be taking information produced by another company and repurposing it or representing it in a different context? If the companies can't, or if the producer of the information can't own the information via copyright, should they be able to claim the kinds of quasi-property interests that Justice Pitney recognized? Or is that in itself kind of unfair? I mean, like the byword today is, information wants to be free. Well, this is precisely a case of courts saying, maybe sometimes information should be free and maybe sometimes it shouldn't. And how should we think about the freedom, as it were, of information under the circumstance? What would make these kinds of torts justified or not? And how should we think about the legitimacy of kind of managing competition in information-based industries through these kind of terms? And maybe think a little bit about that Brandeis position as well, right? I mean, to the extent that Brandeis talks about kind of managing or regulating the market for information in a more kind of deliberate and top-down sort of way, is that a good idea or a bad idea? How should we think about that under the circumstances? Do we want the government involved in regulating the dissemination of information or not? Are there reasons to think that might be risky? And so on. All right. Thanks a lot.